Welcome to this presentation on tribal customary adoption being presented by California Indian Legal Services. My name is Delia Parr and I am the directing attorney of the Eureka office. Starting with some background, tribal customary adoption became effective July 1st, 2010 and was legislation sponsored by the Saboba Band in Southern California. It was supported by tribes throughout California though. As a quick overview, tribal customary adoption is a new permanency option that's more consistent with tribal beliefs and values because it allows for an adoption of an Indian child without termination of parental rights. And instead of using the mandatory provisions of state law, tribal customary adoption occurs according to tribal laws and customs and traditions through the development of tribal customary adoption orders and home studies that need to be approved by the tribe, and we'll talk about both of those things as we go along. A few key points that we need to understand as we get started are that tribal customary adoption is only available when the tribe agrees. Again, it's only available when the tribe agrees. The tribe actually has to put together a tribal customary adoption order that it submits to the state court and approve a home study. Those are things that by law the tribe has to do. And so again, this is just not a permanency option that's available where you don't have a tribe agreeing to it. Also, it is only available in dependency cases. It is not currently available in the family law context or any other context. And last on this slide, it is only available for children from federally recognized tribes. This is not a permanency option available if there is a non-federally recognized tribe as the only tribe involved in the case. So for the next couple of slides, we're going to talk about why the agency, in particular tribes, would consider tribal customary adoption as the most appropriate plan for an Indian child. And let me just say here that it is not the case that tribal customary adoption will be the most appropriate plan in every case, but it is a permanency option that needs to be considered in every case. And along those lines, we need to understand that concurrent planning now will encompass a discussion of tribal customary adoption. And concurrent planning is just that legal requirement that agencies have very early on in a case to be looking at what the options are for the child or children in the event that reunification with a parent or parents is not successful. So, what will the permanent plan be? Who will the placement be? Who will the caregivers be? And so it doesn't take away from the focus of active efforts reunification services, but it is required to be looked at very early on in the case while reunification services are still being offered. Right, so why are we considering tribal customary adoption? Well, we're considering tribal customary adoption because a standard adoption requires parental rights be terminated. And that standard adoption has been associated with assimilation of Indian people. And it causes or has caused a breakup of Indian families, and it has damaged or destroyed connections between children and their tribes, and it has the ability to interfere with inheritance rights. And so going back up for just a second, the way that it damages or destroys connections between children and their tribes is that it can interfere with membership rights in tribes depending on how that particular tribe's membership criteria is laid out. And with regard to the interference with inheritance rights, there is a federal probate law called the American Indian Probate Reform Act that governs the probate of all Indian trust land. And one of the things that that federal law says is that where a child has been adopted out, that child cannot then inherit from his or her biological parents. So that terminates that child's ability to inherit from the biological parents, which unfortunately includes or would provide as a right the ability for that child to potentially hunt or fish or gather on that land. And having a tie to that land is part of how that child may have maintained a connection with their biological family, both biological parents and extended family, importantly extended family, and also their tribe in general. So that inheritance piece is really crucial. So as a result of that, tribes have often opposed adoption and instead supported guardianship as the most appropriate permanent plan. But there are some problems with guardianship. And before I get started here, I just need to be very clear that, again, in many cases, actually, guardianship still will be the most appropriate permanent plan, but that there are some drawbacks and that it is important to evaluate on a case-by-case basis what the most appropriate permanent plan is for that particular child. So looking at the specific problems with guardianship, one is that it is just simply lower on the list, the hierarchy of permanent plans that are available, that the state courts have to comply with, unless there's an exception that applies. In California, courts can order guardianship instead of the more permanent options of either a standard adoption with the termination of parental rights or a tribal customary adoption if the adoption would interfere with that child's ability to maintain contact with the tribe. In that case, the court can look at guardianship as the most appropriate permanent plan, and in many cases, again, this will still be the permanent plan. But there should be a discussion between the tribe and the county and the caregivers around things like funding, that the funding between guardianships and cases where there's an adoption is different, and also the flexibility around services and funding between the two permanency options is different, that there's more flexibility allowed through the adoption assistance payments. So as a result of, though, this historical consideration of whether you were looking at standard adoption with standard adoption with the termination of parental rights or guardianships, tribes were often going into court and fighting really resource-intensive cases, which, the idea is anyway that tribal customary adoption can potentially resolve, and in many cases has been able to resolve. So again, tribal customary adoption is higher than guardianship or long-term foster care on that hierarchy of permanent plans that state courts have to comply with, meaning that it's a more permanent situation for the child, and therefore the courts are obligated by law to favor that. And just to back up for a second, the way that a hierarchy looks is that at the very top you have adoption, with the idea being that you want the absolute most permanent plan available. Right next to that, not below it, but next to it, you would then have tribal customary adoption, that they should be seen as on par with each other because they provide the same level of permanence. Below those two, you have guardianship, and then below the guardianship, you have long-term foster care. So another nice thing about tribal customary adoption is that it allows the tribe to shape the conditions under which the adoption will occur. So through the development of the tribal customary adoption order, the tribe sets the terms of continued visitation with extended family, attendance at cultural events, the last name of the child. The tribal customary adoption order really controls what that child's life will look like within a legal framework going forward, that it takes the place of what the state court adoption orders used to look like. One of the other reasons that tribal customary adoption is looked at as a good alternative to a standard adoption is that there are better enforcement options available if the placement does not comply with the tribal customary adoption order versus the enforcement options that exist for the post-adoption contact agreements. So the post-adoption contact agreements were these agreements that were negotiated in virtually every case where there was an adoption, a standard adoption of an Indian child, and they were typically negotiated between the tribe and the placement and the child's extended family. And the idea was that it was the vehicle by which to ensure or try to ensure continued connection of the child with the tribe and with the extended family. But the reality of those agreements is that they were very, very difficult to enforce. And so, again, tribal customary adoption has built into it some enforcement options, including mediation through the tribe and the ability to bring it back to the state court system. And again, obviously, the big reason that we look at TCA as a very strong alternative permanent plan is that no termination of parental rights is required. There are a couple of appellate court cases that I want to bring your attention to. The first is, in my opinion, a good one, and the second, not so much. The first case comes out of the 1st District, so northwestern California. It actually comes out of Del Norte County, and it just has some really nice language in it. It provides that tribal customary adoption is strongly favored over regular adoption for Indian children, and that in fact tribal customary adoption is the default option for Indian children. On the other side, we have a very procedurally strange case coming out of the 3rd District. And that's in Re AM, and we are going to go into that in greater detail later in the presentation. So, duty to consult. TCA requires the agency to consult with the tribe as early as disposition about whether TCA is an appropriate permanency option if the child does not reunify. Again, this goes back to our discussion of concurrent planning, that it needs to happen very early on. And I included this twice for a reason. And that reason is this is the area where tension seems to exist between counties and tribes. This is where I get the phone calls in my office. But I understand why it happens now. It sounds like what happens is that everybody is sitting down at a table, and by everybody I mean the tribe and the agency and the parents and perhaps even the extended family, and they're all having this really positive discussion in the development of an active efforts case plan, and everybody's on the same page about reunification. That these are the services that we're going to offer, parents are going to engage, these kids are going to go back home, and all is going to be well. But then we also understand that concurrent planning is a legal obligation, and that tribal customary adoption as a permanency option has to be considered as a part of that concurrent planning, and that discussion has to involve talking with the tribe. And there's actually a really good reason for that, again, without the tribe, tribal customary adoption simply cannot go forward. So the agency has to talk to the tribe to determine if this is a viable option or not. But just, I think because those conversations happen at the same time, both in preparation for the dispositional hearing, and that there's not a tremendous amount of time between jurisdiction and disposition, that it just catches everybody a little bit off guard, that everybody initially is feeling really hopeful about this very strong active efforts case plan, and then the conversation changes course, and there's all of a sudden this discussion of, well, what happens if reunification services fail? So I don't have a real strong suggestion around that. I am hoping that as people just understand that it's a legal requirement and that really the goal remains reunification, that some of that tension or conflict will resolve. Continuing to look at the duty to consult, every report basically from disposition going forward needs to include a discussion of whether TCA is an appropriate permanent plan if reunification is not successful. And this, again, falls under duty to consult. So really what the report should say is that the agency consulted with the tribe, and the tribe does or does not think that TCA is appropriate in this particular case. And each assessment leading up to the 366.26 hearing must include consideration of TCA. So we're going to start to really get into the meat now of tribal customary adoption and how this works. You can find the core legal requirements at the Welfare and Institutions Code section 366.24. That section defines TCA and lists the steps that need to be taken if it is selected as the permanent plan by the tribe. And from a tribal perspective, there are two main components to TCA. One is the home study, which is often done, at least in part, by the county as the tribe's designee, and we'll talk about that more. And the second is the tribal customary adoption order. And the tribal customary adoption order must be done by the tribe, that this is not a requirement that is designated to another entity. This is usually put together after a hearing is held either at the tribal council level or the tribal court level. Looking at the home study, either the tribe or its designee does the adoption home study. And currently, at least to my knowledge, most tribes are utilizing designees to conduct the home studies. And the designee can either be a licensed county adoption agency, state DSS when it acts as a county adoption agency, or another California licensed adoption agency. And the home study by law has to look at the Child Abuse Central Index, as well as the criminal background checks through the Department of Justice. And if the tribe doesn't have access to those two things, then it can designate another entity to be able to get it, which is usually the county. And in some cases, the child may have already been placed with somebody other than a parent, so those reviews may have been completed. No adoption placement can happen if there are felony convictions for things listed here: child abuse or neglect, spousal abuse, crimes against a child, or crimes involving violence. And the home study must review the background, safety, and health information about the adoptive home. It also has to look at the biological, psychological, and social factors in the home, and the commitment, capability, and suitability of prospective adoptive parents and home. So this is not as simple as the tribal specification for tribal approval for a foster care placement. That an adoption home study is much more comprehensive in nature and is the reason that most tribes are currently utilizing designees, although it is my guess that in 5 years tribes will be doing more of these on their own, and that hopefully at that point we will have figured out how to get the funding to flow to tribes to be able to conduct these on their own and actually have the resources to do it. Within this framework, the home study, if it's being done by a designee and not by the tribe itself, must be done in consultation with the tribe, and the standards for evaluation of the home must be based on the prevailing social and cultural standards of the tribe. And this is another area where we have seen a lot of tension. And what we've learned is that adoption home studies are really confidential. I had no idea, frankly. Before tribal customary adoption, I had no reason to ever have to deal with adoption home studies. With tribal customary adoption, I have learned that they are so confidential that not even the county social worker has access to them. That if county has an adoptions unit, that unit and child welfare services or the foster care portion keep their files very separate, that the information doesn't cross over, that there are all these very special confidentiality rules. And I share that with you because it makes it really difficult for those entities who are really used to being so careful about confidentiality to share all this information with the tribe. But they have to. And they have to because by law, that home study has to be done in consultation with the tribe. And it has to, again, utilize the standards for evaluation that are based on the prevailing social and cultural standards of the tribe. And here's the biggie, it has to be approved by the tribe. Tribe cannot approve it if the tribe doesn't have it. So I just alert you to that so that you understand that this may be an area of conflict. but that the law is clear that you can go back and look at 366.24, and hopefully once you point that out to the designee that this issue fades to the background. But it's been a tough one. So now we're going to start talking about the development of the tribal customary adoption order. And where we are in the dependency process at this point is at the 366.26 hearing. So we are at the selection and implementation hearing. There may be some argument around what is the most appropriate permanent plan. The court would hear argument on that and ultimately make a decision. And for purposes of our presentation today, we are of course assuming that the court's decision is that tribal customary adoption is the most appropriate permanent plan and has ordered that. So at that 366.26 hearing then, what would happen is that the court would order TCA is the permanent plan for the child, but then wouldn't do anything else. At that point, the state court would just continue the matter for up to 120 days. And it's this 4-month period, this 4-month window of time that the tribe uses to complete and file the tribal customary adoption order, and also to conduct and approve, if appropriate, the home study for the family. So again, we walk into the 366.26 hearing. The court orders tribal customary adoption as the permanent plan, and then nothing else happens at that hearing except for a continuance of up to 4 months. That 4-month continuance can, under law, be continued for an additional 60 days at the court's discretion. Not my favorite slide, but as promised, we are coming back around to have a discussion of the third district appellate case in INRI AM. And this is just a wacky case, and if you get through this particular slide and you're confused, know that that is okay and that you are joining the rest of us, because this case just doesn't make any sense. So I'm going to start by again just explaining what this process should look like, and then I'm going to try to compare that with what it might look like in AM. So what it should look like is that we should again walk into the 2-6 hearing. There might be some argument on what the most appropriate permanent plan is. In our pretend world, the court is ordering tribal customary adoption, and the court continues that case out for 4 months. The tribe then goes back and sets a date for a hearing to determine what the terms of the tribal customary adoption order are. And the tribe then provides notice to the appropriate parties so that they can attend the hearing and have input. So that takes care of the due process requirement that is inherent in these situations. And due process is just simply notice and opportunity to be heard. So if the tribe sets a hearing date, provides notice, and folks can come in and be heard on what they do or don't want in the order, that's due process. So the difficulty that I have, and the reason that I think that INRI AM doesn't make any sense, is that what that court essentially said is that a tribe should come into that initial 2-6 hearing with a developed tribal customary adoption order, and that if the tribe doesn't do that, then the tribe isn't serious about TCA and the TCA doesn't need to be ordered. But if a tribe does that, it's difficult to understand how due process will be afforded to the parties, because tribal customary adoption at that point hasn't even been ordered as the permanent plan. So that hasn't triggered any of the things that the tribe would normally do. That said, I still have to recommend that, particularly for tribes that have cases in the 3rd district, and I included the 3rd district counties on the slide, that they should go into the 2-6 having at least begun and, if possible, having completed and issuing the tribal customary adoption order. And I don't have a lot of additional guidance for you on that, unfortunately. This case has really just created a bit of a mess in the 3rd district. I can tell you that I have had cases in some of these counties since this decision, and they have not been as ugly as I would have anticipated, and they just seem not to be following this particular case because it just doesn't comport with a reading of the actual statute. So there you go. Again, don't let your confusion around this particular slide worry you too much. Our contact information is on the last slide. If this creates a problem for you, contact us and we will try to walk you through it. So the order itself is, again, usually issued after a hearing in a tribal forum. So that's the hearing that is set after usually the 2-6 hearing and after due process has been provided. So notice has been provided to everybody. Everybody's had a chance to be able to come in and be heard on their issues. And then the tribal council or the tribal court then considers very carefully everything that it's heard and carefully crafts a tribal customary adoption order. In many of these cases, in fact, my understanding is that the way this legislation was designed is that it does not need to be a tribal court, that it can absolutely be a tribal council or other body duly authorized by the tribe. So for instance, an ICWA committee or something of that nature. So I just wanted to make sure that everybody was aware of that. The exact procedures to be followed in the tribal forum will vary from tribe to tribe. That is not something that we would ever look to a state court to dictate, that will very much be in line with that particular tribe's governmental process and customs and traditions. However, again, due process does need to be provided, which is that notice and opportunity to be heard before a neutral decision maker, so the tribal council, the tribal court, the ICWA committee, and the child, birth parents, Indian custodian, and proposed adoptive parents and their councils all may be present to provide evidence in the tribal forum. That is a requirement under law, and it's something that the state court can look to in whether or not it can properly issue full faith and credit to the tribal customary adoption order. So the due process piece is important, and those persons outlined there are the persons that should get the notice. Details of the actual order. The exact terms of the order will vary from case to case, but they must describe certain things that are laid out in the Welfare and Institutions Code. And those things include the modified legal relationship of the birth parents or Indian custodian and the child, including continuing contact, continuing responsibilities, what the inheritance will look like. It is absolutely fine for the child to be able to inherit by both the biological family and the adoptive family. It just needs to be very clearly delineated in the order. And the order must also describe the legal relationship between the tribe and the child. The order cannot, under state law, include any child support obligation from the birth parents or the Indian custodian. And that's something that needs to be spelled out very clearly in the order. And it's also really important to understand that there's a conclusive presumption that any rights or obligations not dealt with in the order vest in the adoptive parents. So if things like visitation or continued participation by the child in tribal events are not very clearly delineated in the order, then they are left to the discretion of the adoptive parents. And I want to take just a second here to also provide just a word of caution around these orders. And that is simply that these orders have to grow with kids. And it is in some cases more appropriate to have orders that have broader language than very concrete language. And what I mean by that is that if you are developing, or if a tribe is developing an order for a 2-year-old, it may not be appropriate to include in that order that the child will spend every other weekend with extended family. Because what that has the potential to do anyway is really limit that child's ability to engage in extracurricular activities when the child gets older. Say the kid wants to participate in soccer, baseball, or whatever, but games are held on the weekends or practices on the weekends, and it just may interfere with the ability of that child to just engage in the day-to-day activities of a normal child, and importantly may create unnecessary conflict between the adoptive parents and the tribe or the extended family. So my recommendation is just to look at these really from a very common sense or practical lens, and just think about them growing with the child. So if this order is appropriate now when this child is 2, try to visualize it when the child is 10 and 16 and so on. So let's just take a second to situate ourselves in the dependency process right now before we jump into full faith and credit. So at this moment in this presentation, we have gone through the initial 2-6 hearing where the court in our pretend land has ordered tribal customary adoption. The court continued that for a period of up to 120 days and possibly even additional 60 days at its discretion. And the tribe has set a hearing and provided due process to all of the necessary persons and developed the tribal customary adoption order. So that brings us up to where we are right now. So the tribe has to file that order with the Superior Court at least 20 days prior to the continued 2-6 hearing. And at the continued 2-6 hearing, the court determines whether to give the order full faith and credit, which simply means that the order is adopted as the Superior Court's own, and that state court funding continues, and the order is then enforceable in state court. Basics of full faith and credit, meaning these are the things that the state court can look at when determining whether it's appropriate to provide full faith and credit to the tribal customary adoption order. The state court can look at due process, which is again notice and opportunity to be heard, can look at the general fairness of the proceedings. So, was the decision maker, was that body neutral? This does not mean that everybody had to agree to every provision of the tribal customary adoption order. There's actually a really nice appellate case, a very recent appellate case on point, and we will provide that link along with this presentation. But there's no requirement, the state court also does not have a requirement to adopt an order which would offend important and legitimate state public policy. So if you have a situation where there is a term of the order that would create an excessive burden on the adoptive parents that could be viewed as discouraging adoption, that might be seen as against state public policy. But if a state court is deciding not to issue full faith and credit to the tribal customary adoption order, it really needs to fall into one of these 3 areas. It needs to either have a due process issue, it needs to have a general fairness issue, or it needs to be in violation of state public policy. That aside from those things, the state court should not necessarily be looking at whether or not the terms of the order are in line with what the state court would have done, for instance. The state court, though, can look to the order to be sure that those provisions that are outlined as requirements to be included in the order are actually included, of course. So those things around, inheritance and child support, etc. If you run into a situation where you have a state court that doesn't adopt the tribal order, and I have not seen one of those, but what would happen is that the matter would be returned to the tribal forum for a resolution of whatever the issue was that was identified by the state court. And if no resolution can be achieved, then the Superior Court would then select another permanent plan. But assuming that the court adopts the tribal order and that the tribe approves the home study, then the major elements of TCA are complete. So if you are in a happy situation where the tribal customary adoption order has been granted full faith and credit and the home study has been approved and you have moved beyond that 2-6 hearing, the rest of that case really flows very much like a regular adoption would. That you have, the adoptive parents that need to file a petition for adoption, that there are some final agreements around adoption assistance payments that need to be done and final reports that need to be filed by the agency, and that ultimately there would be a final decree of adoption, and then the court would terminate jurisdiction. So that is tribal customary adoption. If you have questions that come up around tribal customary adoption, feel free to contact one of our offices and we may be able to assist you with that. There are 2 all-county letters. The 1047 that's referenced on this slide is the particularly helpful one. Those 2 letters are still currently standing in the place of actual regulations around tribal customary adoption. Yes, I know that's odd because I said at the very beginning of this presentation that this law became effective in 2010 and this is being recorded in 2016. But I digress. They are working on regulations, so hopefully there will be some additional clarity in this area sooner rather than later. But for now, you're looking at the Welfare and Institutions Code, particularly 366.24. and also all county letters, and in particular, again, it's 1047. And if you have any questions, please call us, and if it is possible for us to help us, we will do that. You're also welcome to email me directly at dpar@calindian.org, and you may want to check out our website at www.calindian.org. We have a number of resources located there on a variety of Indian law issues. Thank you very much. I hope that this information proves useful to you.